Hello and welcome to my video. My name is Siva Shanmugalingam. I'm from Kuching, Sarawak. I'm 47 years old and everybody will be wondering, what is a 47-year-old doing going back to school and studying law? Law has been a passion of mine. I've always wanted to become a lawyer since I was a child. And I made an attempt about 30 years ago. After Form 6, after my STPM, I did enroll into law school, but I failed to get my qualifications. After years and years of being in the industry of advertising and promotion, sales, event management and such, I realized that law was still a big passion in my heart. And in 2018, when my late father passed away, it was his dying wish as well that I go back to school. And in 2020, when I had a heart attack, I realized at that time that my future will be bleak if I continue to do things the way I did in the past, that is rely on sheer strength and energy to earn a living. So in order to have a retirement plan and as well do things that I love, that is social activism, I felt that getting a career as a lawyer will be very, very beneficial to everybody, not just me, my family, but all the people that I wish to help and are already helping right now. So that is the reason why I decided to go back to school. And I used the APEL examination provided by the Malaysian Qualifying Agency to qualify as a student at Unisza. I have to say thank you to Unisza for giving me this opportunity to become a student and to change the course of my life for the future. Thank you, Unisza. Today, I will be giving my legal opinion with regards to a dispute between Andika Bernardi and Atika. Andika purported to sell her albums, collection of albums from Lee Min Ho to Atika for 1,000 ringgit. And in his offer, he specified to Atika that should she want to accept the offer, she should make it through a WhatsApp message on or before the 20th of June. However, Andika sold the records to another friend and he did not inform Atika of a revocation of his offer. So the matter here is whether Atika and Andika went into a valid contract. And these are all governed by the Contracts Act 1950. Now, in the Contracts Act, we find a definition of whether a sale or an offer or proposal has been made, available in Section 2, subsection A of the Act. Now, it states there, when a person signifies to another his willingness to do or to abstain from doing anything with a view of obtaining the assent of that other to the act or abstinence, he is said to have made a proposal. So basically, when you make an offer, it must be clear, and as long as that person is able to accept the offer, it is valid. Section 4, subsection 1 of the Act states that the communication of a proposal is complete when it comes to the knowledge of the person who is made to. So basically, Andika made the proposal and it was in the knowledge of Atika. So there was a proposal, there was a valid offer. Relating to the case, Andika did make that offer, right? And all of this is within the meaning of Section 1, 4 sub 1 of the Act. This brings us to the second issue, and that in the case, which is whether there was a revocation to that offer, whether Andika properly revoked the offer that he made, right? And the answer, plain and simple, is no. Andika did not make a proper revocation. In fact, he totally forgot to revoke it at all, right? So therefore, Atika is still able to enforce this contract by making a valid acceptance. But when you look back at the case, Atika, though she had knowledge that Andika Bernardi sold those albums prior to her accepting his offer, she made a phone call instead of a WhatsApp message. So in the offer, there was a prescribed manner of accepting the offer. The prescribed manner being a WhatsApp message to Andika on or before the 20th of June. However, Atika on the 20th of June decided to make a phone call to Andika to accept the offer. Now, when you go back to the law, Section 5, subsection 1 of the Contracts Act 1950 states that a proposal may be revoked at any time before the communication of the acceptance is complete and against the proposer, but not afterwards. So there was no revocation, very clear. Okay. Lastly, the thing that we need to look at is Section 7, subsection 1 of the Contracts Act 1950, which says that an acceptance must be absolute. Now, Section 7, subsection B notes that an acceptance must be expressed in some reasonable manner unless the proposal prescribes the manner in which it is to be accepted. Now, as I mentioned earlier, Andika Bernardi did make a specified mode of acceptance, and this specified mode of acceptance was not followed by Atika. Atika instead made a phone call instead of the WhatsApp. So therefore, because Atika did not comply with the mode of acceptance, there was no valid acceptance of the contract. And in a nutshell, there was no contract. So to advise both parties, one is Andika should know that when he makes an offer, he should actually wait until somebody can perform the contract. But he did not. However, Atika also did not accept the contract as per the specified way. So in law, there was no contract in the first place. And if there is no contract, it cannot be enforced. And Atika have to accept the fact that Andika's sale of those albums to her friend on the 19th is valid and she cannot enforce the contract. So thank you for listening and have